My name is Patrick DeMay. Um, you may have seen me before in some of the previous webinars. Today, we're going to be going through running a disciplinary process, what people leaders need to know. And of course, as I said, my name is Patrick DeMay. I'm the HR business partner for Australia. I'm basically on hand for anything HR or ER. Okay, so before we begin, just a bit of housekeeping. So questions are of course welcome. I'd just love it if we tried our best not to have any identifying questions in there. For instance, nothing that's going to identify you as a company. The recording will be available after the session, and I'd love to find out what you're looking to learn today. So with all that, let's get into everything. So first of all, who's MyHR? Well, we're an outsourced HR covering all employment matters. So we provide expert HR support combined with world-class smart HR software. So we support over 1,700 Kiwi and Australian employees all around New Zealand and Australia. Our clients range from anywhere to one to 1,100 staff. We deal with all industries and all regions. It's important to note that we've also got cost-effective lock-in contracts. We were established in 2013. We do make HR easy, and MyHR is the department for organizations without one. So now that you guys know who we are, let's go through what to expect. So number one will be grounds for considering a disciplinary, right? We'll go into each thing, of course, in much further detail. Number two would be strategies for managing workplace issues. Of course, the legal stuff, the Fair Work Framework. Now, this is, of course, going to be very, very important. Eligibility for unfair dismissal guardrails, the disciplinary process, prep, notification, response, and, of course, outcome. Of course, some of the legal updates, the closing loopholes reforms, bonus resources, and then finally questions. All right. So part one, grounds for considering a disciplinary, right? So now, of course, there's a lot of different aspects to disciplinary and misconduct itself. Poor performance, misconduct, of course, itself, and then, of course, serious misconduct. So we're going to go into each of those. So now, ground number one, so poor performance, failing to consistently deliver. What is really important to note here, guys, is that this can be seen as misconduct, but it does depend on the way that it's happening. For instance, look, not hitting targets, sloppy communication with clients, not getting enough work done, etc. These are all aspects of possible misconduct. But the issue here is we need to find out, is this a skill issue or is it a will issue? If it's a skill issue, we're looking at a more so performance issue, right? The employee may not know how to deliver, right? They may not understand or have the training to hit their targets, right? Or not get enough of that work done. Now, when that's the case, we can't be disciplining for that, right? We want to go through a PIP, right? On the other hand, where this is willful, right? Complaints from customers, missing deadlines, inconsistent performance, right? This can be looked at as misconduct, right? Where there is a willful underperformance, that is, of course, going to be misconduct. Now, moving on further into misconduct, the general definition. So, this is behavior that undermines trust and confidence in the employment relationship, right? Things like being repeatedly late to work, rude to colleagues or customers, being surly or lacking apathy, not following reasonable instructions or policy. Of course, passive aggression is a massive one. And then, of course, behaving inappropriately. So, look, I'm going to go into how we deal with these things, but these are the general things that we're looking at. And then, of course, now this is probably one of the most important things. This is something I speak to a client about every single day. And the issue is across the board, I find that everybody has their own understanding of what serious misconduct is, right? The issue with that is that the Fair Work Commission is not looking at your definition, right? To be completely blunt. They're not looking at your definition and then they're not looking at mine. They're looking at their own, right? The serious misconduct regulation 1.07, right? Now, it has to be number one, willful and deliberate, right? Willful and deliberate behavior inconsistent with continuing employment or conduct causing serious and imminent risk to the person's health and safety or to the reputation, viability, or profitability of the business, right? Now, I know a lot of employers, have this happen, right? Now, the thing is, when it comes to serious misconduct, that if it fits the example, that's one thing, right? We may have a serious misconduct allegation, right? There's another part to it where we need to also meet that serious misconduct allegation with the amount of evidence that we can possibly with the amount of evidence that we can possibly get, right? Now, what that means essentially is you very nearly need to prove beyond reasonable doubt that the employee did this, right? Now, that would be important, for instance, if you wanted to terminate an employee without notice, right? Serious misconduct, when an employee is terminated by serious misconduct, if we have the evidence to meet that threshold for the serious misconduct allegation, well, then yes, right, we can absolutely do that. Now, a lot of the time when it comes to serious misconduct, we may have the conduct, but we don't have the evidence, right? Now, where this happens, you most likely are going to want to pay the notice. The reason being is because the evidence may not stack up if it was challenged, right? Now, we will go into that a little bit deeper, but the examples that this does specifically list is theft, fraud, assault, sexual harassment, intoxication at work, and of course, refusing lawful and reasonable instruction. One more quick thing on that. Super important for us to make sure that we're not actually stating these things in the allegations. Theft, fraud, assault, sexual harassment, these things are criminal matters, right? Where we state this in our letters of invitation to disciplinary, this is going to cause the onus of the burden of evidence to increase to beyond reasonable doubt, right? What we look at as HR, ER people is the balance of probabilities, right? That is whether or not it is most likely that the employee did the allegation, right? So obviously, when it comes to that, the burden for evidence is a lot lower, right? It's more likely than not, rather than beyond reasonable doubt, right? So very important. I mean, I'm assuming that, for instance, if you did put these through, they would hopefully go through MyHR, that we don't use this language. Okay, so now managing workplace issues. So what are the informal and formal tools? Well, the informal tools would be, of course, masterly in activity, right? Doing nothing, monitoring the situation and stepping in if it doesn't improve. Now, look, this isn't always something that we can do, right? Now, it does depend on the severity of the matter. If, of course, we're looking at sexual harassment, if we're looking at bullying, anything, for instance, to do on that side of things, this is not going to be the step, right? We cannot just do nothing. We cannot monitor the situation. We need to step in immediately. But of course, this is going to depend on the matter. Number two would be gathering information. So understanding the situation, of course, checking there isn't something you missed before you actually go into the action that you're going to take. Number three would be giving feedback. This is part of the day-to-day, right? Helping them course correct, right? Very, very common with new starters. Of course, not everything needs to be formalized, right? We have small businesses, we have large businesses. There are different things that are expected of a large business versus a small business. A large business, it would most likely be expected that things would be formalized, right? For a small business, however, these informal discussions and informal tools are your bread and butter. All right. So now the formal tools. In all honesty, there's a lot more than this. First of all, though, we could look at, for instance, a letter of concern, right? Now, you may know this is a record of discussion, right? There are many names for this. This is what we have given it. Letter of concern is putting the issue in writing, agreeing on the next steps, for instance, whether that be support, training, or coaching. And the great part about the letter of concern is that you can very easily do this in one day, right? This type of meeting for a letter of concern is informal in nature, meaning that you could put your employee to the side, basically address the concerns and issue this letter right after, right? Look, the main thing to know about the letter of concern is that this does not form part of the disciplinary process, right? It does not hold any weight. But what this does do is it puts in place a reasonable management instruction. And this reasonable management instruction is what is going to help us, for instance, if that is breached in the future, right? This is going to help us reset expectations. For instance, maybe there may have been a precedent where we don't do anything when an employee acts up, right? Where that's the case, this is a great first step. We can have the meeting, issue the letter, And this gives us grounds to move to disciplinary if the issue arises again. Number two would be performance improvement plans, right? Now, look, as I mentioned in the beginning, it's very important to separate the skill versus the will, right? Performance improvement plans, however, can be used when there is misconduct in place as well as underperformance, right? Of course, we are formally managing the employee. We are documenting the outcomes. We are agreeing on the timelines and the support. When it comes to a PIP, look, I'm not going to go into too much detail because we are looking at disciplinaries, but essentially the same process, for instance, where we are going to meet with the employee, review, and then if they haven't made it by that review period, they most likely will get a written warning for underperformance, right? Similar, we can do that obviously for disciplinaries. So now, of course, because this is a disciplinary process webinar, we will have more on that shortly. Now, I just want to get into part three. So this is the legal stuff. So the Fair Work Framework and procedural fairness. Now, before I get into this, this would be my basis for essentially everything I do, right? In all honesty. So this section of the Fair Work Act. So Section 387 of the Fair Work Act. A dismissal can be challenged at the Fair Work Commission if it is harsh, unjust, or unreasonable. Now, the reason that this is in my brain for every single process that I do is because it's important, right? The main thing is that we need to ensure that whatever process we are doing matches, right, the criteria that's listed in Section 387, right? It's not all listed here. However, there are main pillars, right? Two pillars are the big ones here, right? You need a valid reason, a substantive reason, and a fair process, right? Every single time, right? Now, if we think of the fact of, okay, if a dismissal cannot be harsh, unjust, or unreasonable, we need to think of what we can implement within these processes that can make it as fair on the employee as possible, right? Now, I'm going to go into detail about what that can be, right? However, it's going to apply, for instance, throughout almost everything we do. Now, the Small Business Fair Dismissal Code applies to employees with fewer than 15 staff, right? Now, if we follow this and a dismissal is deemed fair, absolutely no problems, right? What I need to let you guys know is that when it comes to the criteria, right, what is looked at a small business versus a large business is vastly different, right? Like I said a little earlier, what is expected of a large business is all these things. You would need to meet this criteria each time, right? You would need to have a valid reason, a fair process. That means a fair process would mean giving fair and reasonable notice, right? Allowing the employee to respond in a fair time frame, right? Not making any predetermined outcomes, not taking adverse action against the employee's general protections, rights, or traits, right? There is a lot. However, MyHR is here to help you. So now, moving to the disciplinary process. So what we would generally call this is, of course, an invitation to disciplinary. Now, what this essentially is a formal consultation with an employee. Now, what this could result in is many different things. It may result in a verbal, first, or final written warning. It could be a dismissal, could be with or without notice, but you do need a valid reason and a fair process. The employee has the right to be told everything material to the decision, for instance, the allegations. The allegations should be put to the employee before we've even got to the actual meeting. They'd have the right to request more information if it is relevant, to have any reasonable time to seek advice and prepare a response. For instance, if the employee at some point says, I'd like to get a lawyer, we do need to take that into account and be reasonable. In fact, 99% of what the Fair Work wants the employee to do is to be optically reasonable, of course. And then, of course, on a much deeper level, show as much reasonability as possible, right? So when it comes to these kinds of requests, saying no immediately and things like this can actually detriment us. So allowing that reasonable time to seek and prepare a response, whether that be from a lawyer, whether that be from an employment relations advisor, this is something we do need to allow. Now, one big part of this, and I do want to make a caveat here, is to allow for a support person, right? And that is the main thing here. There is nothing in the Fair Work Act that actually states that you must give them a support person or that they must have one. The only thing it states is that you must not unreasonably deny a support person, right? In all honesty, I would say best practice would be to offer, at the very least, for a representation or a support person, right? In the absence of that, I have seen, even though it is not part of the act, right, that states that we must give them one, I have seen this work in detriment to a lot of employees, if that's the case. And then finally, to reply, right, to the decision makers. Um, they can absolutely reply, right? When it comes to, Australia, you know, they can reply after the fact. That does not change the outcome, however, right? Okay. Now, some of the essentials here. So unfair dismissal, the guardrails around unfair dismissal. Now, this is the main claim that we are dealing with, right? When we are dealing with harsh, unreasonable, unjust termination. So it takes about 6 months for an employee to actually reach minimum employment for a large business and 12 months for a small business. Now, once they reach minimum employment, they have access to make an unfair dismissal claim. Okay. Now, moving from that, it's important to note that some employees are award free and they are also paid above the high income threshold. Now, what's really important to note here is that some of these employees can still be award covered, right? Some of these employees who are very, very highly remunerated can be award covered. So the main thing here, guys, is that they are above the high income threshold and not award covered. Generally speaking, these employees cannot claim unfair dismissal, right? This essentially means that, look, the guidelines that I was talking about just before are not so prevalent with these employees, right? Because they are paid so highly, they do not have the ability to make these claims, right? This essentially means we can be a little bit more commercial, right? When it comes to terminations, it may just fall down to what's in the actual contract, right? Providing the employee 4 weeks of notice, etc. Moving on would be so it takes it's a 21-day actual time frame to be able to lodge an unfair dismissal application with the Fair Work Commission. Now, that's actually just gone up in terms of the actual the amount that the employee needs to pay. I believe it's around $95 now. But they do have 21 days from the termination to claim unfair dismissal. Now, whether that be off the back of a redundancy, off the back of a termination from a disciplinary, this is going to matter, right? After 21 days, what I do need to make you aware of is that employees can have this extended, right? The 21 days can be extended upon reasonable grounds, right? If there are extenuating circumstances, they will allow it. And then finally, guys, max compensation for unfair dismissal is 91,550 as of 26. Now, the lesser of this or 26 weeks pay. Now, what I do need to let you know is that I've never seen this. I've never seen it be the max compensation. I generally would say that it does not tend to be the max. However, of course, that does not mean we should be, keen to get into an unfair dismissal claim. Now, thresholds are indexed on the 1st of July each year, so this will change this year. And one thing I also wanted to mention was there is another type of claim called general protections, right? This is adverse action. These claims work differently and they do not have a cap, right? So no 21-day cap. Okay. So now with all that gone through, let's go through the disciplinary process, right? So as we said, prep, kickoff, response, and outcome. So the first step would be, of course, the invitation. So the letter is going to set out the alleged misconduct in allegations, as well as any evidence that we have. Now, that could be CCTV, that could be witness statements, etc. One thing that I have seen in case law is that 24 to 48 hours is a reasonable time frame in the eyes of the Fair Work Commission. I would always say 24 at the very least. The only time where you can actually get away from this is if the employee agrees without duress to have the meeting earlier, right? Again, though, that needs to be documented, right? The main thing with pretty much everything is that we need documentation to prove that essentially anything we've done has actually happened. Stage two would be the meeting. put the allegations and the evidence as well as the support person to the employee, right? Now, the allegations, of course, during the actual process, now we need to be careful of the language that we use, right? Try and use a sort of curiosity type language rather than a accusatory language, right? What we're trying to avoid here is essentially this turning into a any type of argument, right? We want to stay as emotionally neutral as possible, right? Um, this is simply for the employee and of course for us, right? We don't want this turning into anything else. We don't want this, of course, breaking apart and we aren't able to finish the meeting. So being neutral in that sense is very, very important. Um, Once this is done, once we have been through everything, we've asked everything about all the allegations, we've put that to the employee, we've got the responses, right? This is where they're admitting or denying, right? From here, we can weigh the evidence based on the balance of probabilities. Now, what we're using for that balance of probabilities is all the evidence that we've got, right? Along with what the employee said. So now with all that, we need to balance, okay, is it more likely than not that the employee did do this? From there, hopefully it would be a 24-hour period. And then, of course, we would either give the written warning, termination, and confirm in writing, right? Look, if this was done with MyHR, I would implore you to call us and get the documentation ready. Now, guys, the prep. So the invitation letter, as I was saying, and we're going to spend too much time because I've just gone through that. What needs to be noted in the letter is the specific misconduct alleged, very, very clearly stated, right? This includes, for instance, whether any profanity was used, that needs to be actually added, exactly how it was stated, regardless of how unsavory that might be. Now, the evidence relied on, right? Invoices, receipts, CCTV, witness statements, emails, and reports. This should be added to the invitation, of course. Now, of course, we want to allow 24 hours support, 24 hours notice so that they can arrange a support person. We would like to give them, of course, a structured agenda. We would need guidance in minutes notes. Of course, this isn't for the employee, this is for us, to make sure that we've actually got everything documented. Um, an invitation to respond to the allegations at the meeting, of course, and then potential outcomes up to a written warning or termination need to be within the letter, right? So when we say that, right, for instance, if we are looking at termination, we need to state within the letter that this is what we're looking at. Potential outcomes may be a written warning or termination, right? This is something that we should state. Now, the actual meeting, right? So holding the meeting, of course, face to face is always preferred. A support person is always welcome, as we've said. We need to put the alleged misconduct and the evidence to the employee, work through the structured agenda, and as I said, try and give them a genuine chance to respond, right? What is insanely important, and I cannot stress this enough, is please do not reveal or decide the outcome in the meeting, right? One thing I will never do for any of my clients is draft a written warning before we've actually come to an outcome. The reason for this is because these things can be found in discovery when it comes to going to tribunal. That's number one. And number two, I find that a lot of employers unfortunately bring the written warning along with them. Having that in the meeting is essentially not going to work well for us, right? This shows a predetermined outcome straight up. We really have no leg to stand on after that. So what we want to do is we want to answer the questions and then adjourn to consider, right? Very, very important we do this. Now, the last part of this is, of course, the response, right? To their side of, or sorry, the second last, I should say, their side of the story. Now, the employee will respond to each allegation. They can, of course, admit it or deny, right? This doesn't mean 100% that we can prove it or not prove it. Now, you'll substantiate on the balance of probabilities with your evidence, right? So based on what they've said, and of course, based on the evidence. So like we said, invoices, receipts, CCTV, witness statements, these are all the things we're looking at. We want to ask questions and clarify, right? Now, as I said before, we don't want to challenge, right? We don't want to challenge or decide yet. We are simply listening. We're asking questions and we're listening to the responses. Some of these responses, if they are fibs, if they are lies, if they are inaccurate, are not going to work well for the employee. Now, we want to listen to genuinely consider everything that's been raised, and then finally, of course, adjourn, right? No outcome. Now, this is where we do move to it, right? We move to the outcome, right? 24 hours afterwards. Now, we want to take our time to genuinely consider their response before deciding, right? And now this is the reason I'm telling you to give 24 hours. Giving a outcome right afterwards, right, shows that we didn't consider it, right? Or maybe we had a predetermined outcome. Now, once we've done this, once we've taken the time, we can confirm the outcome, whether that be a written warning, a PIP, or termination, right? If it is termination, we give 10 to 15 minutes to consider that and then listen, right? Look, in all honesty, proposing termination, does not mean that the employee, has to respond to it, right? In Oz, we're more of the sense where we are more so telling you rather than we're giving you, something to give us a response to. So once that's done, please contact us, contact your MyHR advisor for guidance, or for instance, to confirm the outcome. I would probably rather the latter, in all honesty, right? Um, I would say the best case scenario for any of these or any of these processes, sorry, is to make sure that you're doing it hand in hand with a HR advisor. And of course, finally, confirming everything in writing. Now, here's some of the watch outs. So here's where I've seen employers come unstuck. So as I said, at the Fair Work Commission, most unfair dismissal findings turn on the process, so not the underlying reason. Which is why I feel like a lot of employers find it unfair. Because look, there may be real reason for the termination, but where we don't have that and where we can't prove that, that is the issue. So one of these things is no valid reason, right? Or the reason was never put to the employee. We can have that or simply that it wasn't in writing, right? A lot of this stuff gets done behind closed doors, for instance, verbally. A lot of small businesses tend to use just verbal warnings, verbal this, verbal that. The issue here is that none of this holds any weight for when we want to terminate the employee. Now, if you were to get to a point of we have terminated the employee, perhaps it was regarding performance. We've had many, 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 many verbal occasions where we've told the employee and we've warned them, etc. Now we've had enough and we want to terminate. Essentially, on paper, we've done nothing, right? And that's what Fair Work can see. So making sure that we have the valid reasoning, the valid documentation, super important. Um, Refusing a support person at the meeting is another massive one. Like I said, we cannot unreasonably refuse. Um, like I mentioned in the last slide, a predetermined outcome, that is a massive one. This is one that I probably say would say 95% of the issues I've had to deal with after the fact are predetermined outcomes. No genuine opportunity to respond before deciding, right? So maybe we didn't even have a consultation meeting. Maybe we just had a look at the evidence and we made a decision based off that. This, of course, is going to make us come unstuck. And another one would be no prior warnings for unsatisfactory performance. We've actually been through that. And of course, acting on the day with no documentation to back it up, right? So as I've explained, there is a reverse onus of proof when you go to Fair Work. Everything that the employee says will be taken as basically truth until you can prove otherwise. So now, going through a few legal updates, right? So now, look, there isn't a lot that's changed on the disciplinary front, right? Or how we're going to manage employees in that sense. However, some things have changed. The right to disconnect, refusing unreasonable out of hours contact, sorry. Now, 15 plus staff from August 2024 that's already in for them. And then of course, small businesses from August 2025 already in, right? So at this point in time, we're simply looking at, all right, what is unreasonable and what is reasonable in terms of contact for out of hours, right? Now, to go through that, please contact your advisor, right? There is a lot that we can actually look at in terms of what is reasonable versus what isn't. Wage theft. This is the big one. Now, wage theft is a criminal offense, of course, from the 1st of January 2025. This has been in effect for a year. Now, it's a bit slow in how this is happening. I still have not seen any case law for this. However, I know that there are many, 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 many employers that are underpaying staff. Now, the important thing to note here is that when it comes to underpayment, where it is willful and deliberate, you will be seen as underpaying and it will be seen as wage theft, right? Willful and deliberate wage theft, right, is a criminal offense. Now, unfortunately for that, there is 10 years or up to 10 years imprisonment and 1 million plus in fines for the individual, 10 plus, I believe, for businesses, right? So it can be very, very costly. What is important to note here, right, is that look, people underpay all the time and it's accidental, right? Where it is accidental, this is okay, right? We have the chance to fix this. We have the chance to either, if we are a large business, we may have to dub on ourselves to the actual commission, right? There are pathways we can take. If we are a small business, there's generally a lot more leniency. You can take a little bit more time to rectify this with the employee. But the main things here, guys, is making sure that we notify, rectify, make sure it doesn't happen again. Another one would be same job, same pay for labor hire workers. This one's come in just recently. Casual employment, new definition. Obviously, the new employee choice pathway. This came in quite a while ago, so hopefully, quite a few of you guys are across it. But what this means now is that casuals, it's on the employees. Sorry, the onus is on the employee to actually request for full-time or part-time work. And of course, fixed term contracts. Now, this changed recently. They are now capped at a max of 2 years or one renewal. Now, this does not apply if your work is seasonal, for instance, or if there is a genuine reason for the actual change in fixed term. Um, there's those two reasons as well as the fact I believe, for instance, if you are moving from one fixed term contract role to a completely other fixed term contract role, that's not a problem either. And then finally, guys, now the Fair Work Commission can hear unfair contract terms disputes below 183K, right? What this is basically sham contracting, right? So essentially, I'm not going to go into too much detail about that because it's a very big, big can of worms. But sham contracting, of course, is one of the big things that the Fair Work Commission has been looking at the last 2 years. So we need to ensure that our contract terms for contractors are correct. They reflect contractor terms rather than employee terms, and we're safe. All right. So now, how can the platform help? Right. So we can help in a few different ways. Right. So now this isn't one of the only things. Now we can capture feedback as it happens. Right. So now this is great because each manager can put these notes on each employee's profile. Right. Now this can help, of course, us track information or Fair Work Commission if it ever gets to that point. It helps us see what evidence trail we have, and it's ready, of course, whenever we need it. So moving from that, another way we can help is asking us, right? So we have a 4 hour turnaround for any chat queries, right? So when your issue comes about, you can basically rely that we're going to be on the other side, ready to answer you, right? If you want to get to us quicker, we do have a line, right? I would say 99% of the time, it's a lot easier, for instance, for you to pick up the phone, get on a ring with us essentially, and we can get it all started for you. The main things here is that we're real HR experts, not a bot. Now, we have your back when it comes to documentation as well. So when I mentioned letters of concerns, PIPs, disciplinary letters, really any documentation, we can absolutely write these for you, right? We can write these for you. We can guide you through the process stage by stage. And of course, we actually have a 24 to 48-hour document turnaround time, right? Um, the main thing, of course, like I said, is to call us if everything is urgent, right? We are real HR experts on the other line. So please rest assured that your documents will be done, for instance, by somebody who has been in HR for years and customized to your liking. All right, guys. Well, looks like we got through that a little quicker than I had expected. So that is good because it gives us time for essentially some questions. So I'd love to see if anybody does have any questions about this. I'm sure that there would be, some here or there. Is there anything, for instance, that's happening with yourself? Of course, not to identifying, and I can absolutely help out. Well, it looks like we've got a few. in regards to the unfair dismissal, if an employee has been with a company for under 6 months in a business with over 15 staff, they cannot make a claim. Okay, so let's answer this. So, okay, if an employee has been with a company for under 6 months in a business with over 15 staff, they cannot claim. Okay, so yeah, this is correct, right? If it's under 6 months with a large business, look, they can't claim for unfair dismissal, right? This is the main thing here. Um, when it comes to unfair dismissal, it's important that they actually have the access to actually do it. If they don't, the ombudsman, look, I won't lie, have seen some very, very strange occasions where the ombudsman will say, look, I'm happy to see this, right? Um, but the thing is that's not very often, right? 9 times out of 10, right? The employee will, if they're trying to claim for an unfair dismissal claim before that point, they will get rejected. Okay. Show cause. When does the show cause process come into play? Okay. Um, so this is a fun one, I guess. Now, show cause is something that you can use for disciplinary, right? The thing is, I find that a lot of businesses use show cause in funny ways. Show cause is something that I would generally use, um, generally for possibly when an employee is sick, right? And it's a no longer a temporary illness, and we're trying to get to the point to show um physical incapacity or legal incapacity, right? That's generally what I'm going to use show cause. Show cause can be used for disciplinaries, however. Let's say you have an employee, they've worked with you for many years. There are quite a few written warnings on file, right? If this is the case, we may move to a show cause. We may say to the employee, hey, based on X, X, and X warnings over X amount of time, can you please show cause as to how you plan to fulfill the aspects of your role to the standard that we require, considering X, right? Look, show cause can be used, right, for pretty much anything, right? But in all honesty, I would say show cause for myself, for how my HR does it, we tend to only really use show cause or that process when we're looking at, like I said, physical incapacities, right? Let's say the employee um has had a temporary illness, right? It's been longer than 3 months. They have no sick leave left. Now we're at the point where we want to terminate due to that incapacity, right? Show cause is perfect for this, right? Similar to legal incapacity. Let's say the employee loses their visa or loses their right to work in Australia or loses their license, something that is tied to the contract. That's when we can use show causes, I would say. All right. Okay, next one. How would you deal with an employee who has had their probation extended? Does the probation plan transition to a PIP at 6 months? Well, this is going to depend, Shelley. So I think we can. I absolutely think we can. Um, if we were going to extend probation, right, I think, look, it is a very sound thing to try and go straight into a PIP, right? If we are extending the probation, obviously something's gone wrong here. Obviously, the performance is not right. We're not at the point where we want to be. Or, for instance, maybe there's been too much sick leave or too much annual leave that we now want to extend it. Look, dependent on the circumstances, I think whether or not we use a PIP or not, right? So, for instance, if that was the case, it was underperformance, and you know that we want to extend the probation due to that, I would say yes. Let's transition to this into a PIP. Because the issue is, I guess, you know, I'm assuming you're a large business. If they pass the 6 months, then they have the access, right? From that point, of course, if we're trying to um, show the underperformance and document that, of course, the PIP is going to be the main thing that's going to help us, right? Now, an employee still under 12 months, right? After, one or two PIPs, dependent on how much we've actually tried to help them over the period of time, will depend on whether or not we may be able to terminate, right? The main thing I do want to let everybody know here is that these things are super case by case. So when it comes to these kinds of questions, there's a lot that, you know, is maybe unsaid or that maybe, we would also want to look at as well, right? So there's not always just a sort of blanket kind of process, I find. I do like to tailor my processes to the client. Okay, that's that one. All right. So if an employee refuses to attend a disciplinary meeting, which I've dealt with before many times, but supplies a written response instead, what can the employer do in this case? So, look, this depends again on the circumstances. Why are they writing, why are they giving us a written response instead? Is there a real reasonable reason as to why they're not meeting or attending the disciplinary meeting? For instance, that could be another disciplinary matter itself. If the employee does refuse to attend a disciplinary meeting, there needs to be reasonable grounds, right? Um, for instance, let's say they're sick, they're whatever it may be. If they're extenuating and fair reasons, sure, right? That's actually okay. On the other hand, we can absolutely reschedule, right? I've dealt with a lot of these matters where employees are consistently wanting to reschedule, right? There is a point where we say no, right? Being reasonable means maybe saying yes once or twice, right? If it is a reasonable time frame. But essentially, where things start to become unreasonable on the employee's side, where they refuse to attend a disciplinary meeting, where they were supplying a written response instead of doing that, was it reasonable to do so? Why did they do this, right? If it's more of a retaliatory misconduct issue, absolutely we can deal with it. Okay, if it's aggressive behavior, including swearing, what should we do in that instance? What should we also do when an employee uses mental health? So, guys, this is a massive one. Something I deal with every single day is oh, I've got mental health issues. Oh, I've got this, I've got that, I've got that. We all do, right? I have mental health issues myself. Now, the main thing here, guys, is that we're not taking adverse action because of their mental issues, right? The thing is to try your best to not sort of freak out when we hear the mental health part, right? Of course, this is going to make things a little bit harder, but the main thing, I'm fairly sure, hopefully I'm correct when I say this, that a lot of us are not taking action against the employee because of their health, because of their mental health, because they're depressed, because whatever it may be. We are taking action due to issues regarding the workplace and what's happening there. Now, that may come into play, but that's not what we're focusing on, right? We are focusing on the conduct, right? So when it comes to aggressive behavior, swearing, anything in that instance, right? We can still deal with this, even if they do have mental health issues, right? They could have borderline personality disorder, right? And if they still swear or are insubordinate, or if they are consistently involved in misconduct, this is stuff that we're still going to be able to discipline for. Where those things come up in these meetings, absolutely, we can acknowledge it, move it to the side without, of course, undermining it, and let them know that look, we have resources. For instance, maybe we might not have EAP, but we can give you access to those resources whatever they may be. It may be Clearhead, it may be us setting up a GP appointment for their mental health, right? But that's separate from the misconduct, right? So very important to separate these things in the meeting where it does come up. We only speak about what is actually in conjunction with the misconduct, right? Otherwise, we would have a formal welfare meeting with the employee, which is something completely separate. Okay. All right. Given that the employee who has been convicted by a court, for example, sexual assault, can an organization base on that to dismiss the employee? It does depend. So unfortunately, when it comes to criminal activity, we are unable to um, discriminate, right? So, for instance, depending on how this is sort of come about. So, if an employee who has been convicted by a court for sexual assault, right? If this is something that you guys found out, you know, during maybe the on hire process, look, probably something we can do in terms of rescinding, an offer, an offer or something like that. However, I think from reading this, it looks like maybe the employee was already hired, and then we found out that the employees actually had been convicted in the past. That makes things a little bit harder, unfortunately. Um, most time, 9 times out of 10, we will have wanted to do the police check before we've actually brought the employee on. So I'm not sure 100% in which way we've done this. Did this girl that they ignorantly fell into the conduct was not deliberate and will not necessarily bring the organization into disrepute. Look, in all honesty, this is quite a an in-depth one. I probably want you to reach out, and we could get into this in all honesty. Okay, breach of safety, where they put themselves in harm, others in harm. This can be no, guys. There's no instant dismissal. This is really important. There's no such thing as instant dismissal, right? You need to make sure that this is documented, right? Wherever this is, so for instance, serious misconduct, even in that sense, right? We can't dismiss them instantly. To dismiss instantly would be to make a predetermined outcome, right? That's the main thing that we want to avoid. I understand where there's lots of things where employees may be in danger. There's other aspects where, hey, maybe instant dismissal might be the better thing to look at than an unfair dismissal claim. And I have actually advised that before, where it's a safety issue, where it's something like this. Look, where they are putting somebody or their other or others in harm, themselves or their other or others, this absolutely is serious misconduct, and it most likely will be dismissal. The main thing here is that we can suspend immediately, right? Because there is no instant dismissal, we need to do the fair process. We can suspend them immediately, follow that up with an invitation to the disciplinary meeting, have that 24 hours right after, right? And essentially, off the back of the serious misconduct meeting, most likely we'd be terminating, right? So the main thing, guys, is really when it comes to termination, please refrain from doing it on the spot or on the same day. This is generally speaking where I see the most or the majority of my claims. Wouldn't a breach of visa be dismissal if they don't have a visa, they can't work? Correct. But you still need to go through the process for it. For instance, yes, they can't work, means they can't come to work once that's the case, right? But we would still need to do a show cause, right? We would need to do a show cause essentially to show that the employee, yeah, no longer has the ability to work in Australia. Therefore, we are asking you to show cause as to how you plan to fulfill your role, right? At that point, we've given them a reasonable amount of time to respond. Obviously, we've gone through the correct process. Look, 9 times out of 10, they cannot show cause as to how they plan to fulfill the role, right? If that's the case, we are moving to termination. Okay, I've heard the Fair Work courts are flooded with claims. Are PIPs ever genuine, or are they always used as a process of termination? I would hope so, Tracy. I would absolutely hope so. Look, when I the ones that I've done with my clients are absolutely to help the employee within their role, right? That's not to say that they aren't also a tool to move towards termination, right? No, I've definitely dealt with a lot of employers who want to implement a PIP to obviously push the employee more so to termination because they may know that the employee doesn't want to be on a PIP. Look, that's not essentially the wrong thing to do per se. I mean, look, the process, if it's done correctly, that's the main thing, right? I would say best practice, of course, is to make sure that we're putting through this PIP to ensure that the employee improves in their role, right? And we're giving them a fair opportunity, a fair and reasonable opportunity to actually get better. Now, if we are creating a PIP, right, even if they are to push the employee towards termination, it still needs to be a valid one, right? So that means it needs to be accurate in terms of SMART goals, in terms of basically everything that we're putting in there, right? Because we still need to treat this as if it's something that the Fair Work Commission could look at. Now, when you say that they are flooded with claims, yes, they are flooded with claims. Reason being is because of AI. AI has made it very hard for a lot of businesses in the sense where anybody with a computer can now make a claim, and a good one. That's the issue. Okay. Is issuing a PIP as an outcome for underperformance considered as a disciplinary outcome where there is no warning along with it? I wouldn't say it's a disciplinary outcome. It's an outcome. There's many different outcomes we could have as an outcome, for instance, for underperformance. Issuing a PIP as an outcome for underperformance, I mean, look, you'd have to look at it in the way, what is the underperformance specifically, right? I mean, if it's a disciplinary outcome, right? I mean, they would have had to have not met something willfully, right? If we're in the middle of a PIP and let's say we've gotten to the first end of the review period, KPIs have not met, we are specifically saying this is a written warning for underperformance, right? It's not considered a disciplinary outcome per se, right? However, it does form part of it does actually hold weight on their file, right? So if we were to move towards termination, these warnings are actually going to help us. Should you extend a PIP or create a second one if they fail the first one? Sometimes. It depends how long they've been with you, in all honesty. Look, if it's if we're in the 6 month mark, 12 month mark, one pip, two pips maximum, I would probably say is going to be a fair and reasonable amount of time for the employee to improve. So depending on your size of business, most likely I think we may be able to look at termination. All right. There's quite a few other questions. Ooh, we've got a few minutes left, guys, so I won't be able to get through everything, but I'll try my best. Okay, so now which disciplinary process or laws will apply to an employee working in Oz, but as an expat in a global organization? So the home country or the host country, right? So the the legislation that's going to apply is generally speaking going to be the host company, right? So the host country. Um, there may be some globally arranged terms, right? But they would have to sort of meet the same regulations that Aussie would need, right? So for instance, let's say you may have an organization across NZ, Canada, right? The issue there is that your AU employees are not like the AU legislation and awards Fair Work Commission framework is going to apply to them, right? Same with PayG, same with super, same with workers' compensation, right? So there's quite a lot to cover on the Aussie side if you are going to have that. If an employee goes from casual employee and then goes to a full-time employee, casual for 2 months and then full-time for 6 months, no, no. Does the probation period restart? No, it does not. So this is what's important to note though. So when it comes to probation and length of service or continuous service, these are two different things, guys. So continuous service is simply the amount of time that the employee has spent at your business, right? So for instance, let's say it's a casual, right? Well, that continual service is sporadic. They most likely weren't working for the entire 2 months, right? So the amount of time that they did spend with you as a casual working for you, so those shifts that they did have, are going to count towards continuous service, right? So now that may mean that, look, the employee may have worked 15 days in that 2 months. So now they have 15 days continuous service out of 6 months, right? So that's sort of how it's going to work, right? Try and think of your probation generally is more of a managerial kind of tool, right? Rather than anything that's um ever enforceable. Okay. Sean, so can I give a pay rise to 183,000, then sack them the next week? Theoretically, possibly. Look, I must say, look, it sounds a bit concerning. However, it's possible, right? There's most likely going to be a lot of other things I'd want to have a look at, right? I mean, look, an employee could be at 183K or above, but they might be covered by the award. And remember, that is still going to cover them, right? If they are covered by an award but past the high income threshold, then absolutely, they're still going to have that access. Okay. What if somebody gets upset and leaves in the middle of work and comes back to work the next day or 2 days later and saying mental health break, using psychosocial hazards as an excuse? This is a common one, actually, I find. Um, Discipline, in all honesty. That's not an excuse. It's not a good enough one. The main thing here, guys, is that be reasonable where reasonable. That is not reasonable. You know, leaving work in the middle of the day, right? Coming back 2 days later, not being contactable, regardless of whatever mental break that you're going to have, right? Look, there is an aspect of notifying the employer at the very least, number one, right? Look, if we look at your company policies and procedures, right? Regardless of that, we're not giving them a warning or disciplining for the fact that they've had a mental health break. They can have a mental health break, but they need to tell us. And that is the main thing here. We're not taking any action against the employee for having a mental health issue. We are taking action against the fact that the employee left in the middle of the day and did not tell us for 2 days, right? That is the disciplinable offense. Thank you so much, guys, for attending. And of course, register for any other webinars that I'm doing. Of course, they're all free to attend. They're free for everybody. Hope you enjoyed it. Thank you.